Hi everyone, welcome. So in today's live, we are we are going to be talking about the responsibilities of supporters and sponsors that file affidavit of support or that filed an I-134a for the parole programs. Okay, so we're talking about not just the affidavit of support, the I-864, but also the I-134a because they have completely separate responsibilities. Okay, so if you're filing for someone, if you're supporting someone for the parole program or you're sponsoring someone to get their green card, the requirements are going to be different. And you want to make sure that you know what they are and that you are okay with taking on that responsibility. Okay. You have obligations to the person, to the US government, and you want to make sure that you are following through on your obligations. Excuse me. So, if you filed an I-134a, you're going to want to pay attention because your responsibilities start the second the person enters the US, okay? This topic actually came from a question that a viewer that's always here asked in, I believe, my last video. And it is so important. And that's why I tell you all, put your questions in the comments because sometimes I just do a whole video just based on your questions. So go ahead, ask me your questions. It is so important that you're getting your questions answered. And sometimes your question becomes the topic of the day. All right. So let's start with the I-134a because that's the one that the person asked specifically about, because I want to make sure, again, you're getting your questions answered always. All right. Oh, and by the way, if you don't know who I am or why you should even listen to me, I am U.S. immigration attorney Lillian Chukura, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. All right, so let's start with the I-134a. So when you file an I-134a for someone that's trying to get paroled into the US, you want to make sure that you are aware of the responsibilities that you have, your obligations to the supporter. Okay, so your obligations, let's start with how long your obligations are for. So your obligations is until the parole ends. So right now, the people getting parole from Haiti and those countries are getting about 2 years parole into the US. So your responsibility as the supporter lasts for that 2 years. Okay. After the 2 years, the person is supposed to either leave the US or they have already filed for asylum or another means of staying in the US permanently. And if they haven't done that, that's not really your responsibility. They have to figure it out because now they are out of status. All right. So you want to make sure that you know this responsibility lasts for 2 years, if that's how long their parole is. If they get their parole extended and you are still their supporter, you're also extended on your obligations, okay? So when the person arrives in the US, so the person gets their parole, they get on a plane, they get to the US. The second they land in the US, your responsibilities start. That's when it starts. So the first thing is you need to provide them with initial transportation and housing from the airport. Okay. So if they have no other way of getting from the airport or having a place to stay, that's your responsibility. Okay. You are obligated to make sure that they get from the airport to a safe place to stay for that initial housing. So let's say, for example, they land in your city, but family in another state that they will be going over there and living with. That's completely fine. But that initial landing in your city, you need to make sure that they are in a safe location for housing until they get to their family that they will be staying at. So it's really, really important that when you're doing this, you are having conversations with the person you're supporting to make sure that they have actual plans of what they're doing once they are in the US. Okay. So initial housing and transportation is on you unless they have other means of taking care of that. You need to make sure that they have safe and appropriate housing. So they are not living on the streets, right? You are the one providing the safe and appropriate housing, or they have other means of having an appropriate housing. And that's for the duration of their parole. So for that 2 years, they're not going to be homeless because either they have another way of having a place to live that's safe, or you, the supporter, are providing that safe space. Again, this is just if you file an I-134a that you have this obligation. And then helping the person if appropriate, right? They say as appropriate. You're going to be the one helping them, apply for work authorization, or help them connect them to organizations that will help them apply for work authorization, apply for their social security card when the time comes, and any services. So if they need to apply for health insurance, you are either putting them in touch with organizations that are there to help them, or you as the supporter are taking on that obligation to make sure that that happens. So either you're doing it yourself or you're getting them to a place that will help them do it. All right. So this is part of your obligations, is to make sure that they have what they need to apply for work permit and their social security card and any other services that they may be eligible for. And then when it comes to the health insurance, it's also part of your obligation to make sure that they are that their medical needs are met. Okay, so if they can apply for health insurance, that you're helping them apply for that. If they need to go to the hospital, if they need to get medication, that you are supporting them through that, either by making sure that they have health insurance, or that you are paying for that, or that you're connecting them to free resources, so clinics and things like that, that will help them get the medical healthcare and medical needs they have. And that's for the duration of the parole. Okay, this is not just one year you do this and then you're done. No, this is for the duration of the parole. And like I said, those paroles are about 2 years. So you have that responsibility and obligation for 2 years. And then finally, you also have an obligation that's appropriate to help them with assessing education, learning English if that's something that they need, employment, if they have children, or if you are also supporting children, that the children are getting enrolled in school. All right. These are all part of your responsibilities and obligations as a supporter under the I-134a for the parole programs. So sometimes people, ask, oh, do I have to do anything? What if they're going to stay with family? Yes, they can stay with someone else that's not you, but you need to also know that you are still on the hook to make sure that where they're staying is safe, and that they are getting access to resources that will help them basically for the 2 years that they're here be able to build some form of secure life. Okay. If they don't speak English, you're connecting them with resources to help them learn English. So for example, in the city my office is in Worcester, the public library has a free ESL program. So you can go there and learn English. And that's what they mean by helping them learn English. It doesn't mean that you're the one teaching them, but giving them the information of where to go and helping them get there. Okay. So it's really important that you know that when it says learning English, when it says securing employment, it doesn't mean that you're the one hiring them or that you're the one teaching them. It just means that you're putting them in a position where they are able to actually get that resource. Okay. So if you're able to connect them to, like I said, the public library, if they do that in where you live, or other organizations that teach English as a second language classes, those are things that you can do as the supporter to basically support the person. Okay. And that is it. Those are your responsibilities, the I-134a. So this is a financial and kind of holistic responsibility. It's not, you're not responsible for the person if, let's say, they do something that's against the law. That's on you, right? It's just more of making sure that they are able to live, work, have a place to sleep, have a place, have food to eat. That's really the bulk of what we're at here as far as your obligations are concerned. If the person, like I said, decides to go and commit a crime, you are not held responsible for that. That is on them as the individual. Okay. It doesn't come back at you. And you're not going to get arrested just because the person commits a crime, because you're the supporter. All right. It's really important that I say that because I've had people ask. So the next thing we're going to talk about, we're going to go to the I-864. This is the affidavit of support for green card applications. So when you are filing for your spouse, your siblings, your children, right, you're going to file an affidavit of support. If you're filing for your parents, you're also filing an affidavit of support. So it's for when the person is going from no status to a green card. All right. The I-134a is for parole. It's temporary. It's 2 years. And then they need to figure something else out. But the I-864 affidavit of support is for people getting a green card. First off, your obligations, your responsibility does not start until the person's green card is actually approved. All right. So if the green card is not approved, you don't have an obligation, even though you filed an affidavit of support for their case. All right. Your obligation only starts once that green card is approved. If it's not approved, then there's nothing for you to do there. Right. So just filing the I-864 on its own does not create the obligation. Is filing the I-864 and the person being approved and given permanent residency in the US, that's what creates the obligation. All right, so those two things need to happen for you to have any obligation to do anything for them. All right. One thing though, when it comes to this, when you file an affidavit of support, you're saying that this person is going to be financially secure, right? Either they're providing their own finances, or if they're not able to. So it doesn't mean that you're providing housing for them, that you're providing everything for them. It's just saying that if you are not able to do this, right? If that person is not able to work, if that person is not, able to do things on their own, that you as their sponsor are willing to take on that responsibility, that financial responsibility for them. All right. So the I-864 is purely a financial responsibility thing. It's not a you have to provide housing, you have to do all of that. The government just wants to make sure that this person that you're sponsoring is not going to need government assistance. They're not going to need food stamps, things like that, because you are saying that you will provide for them if it ever comes to that. In most situations, it doesn't come to that. For children, of course, the parents are going to take care of their kids. So even if you're the parent filing for your child, it's a given that you will take care of your kids anyway. So that's not really a big deal. Where this gets a little complicated is where, let's say, for example, the husband is filing for their wife, and then they are together for, let's say, 5 years and decide to divorce. Once they divorce, guess what? The husband that filed the affidavit of support is still the sponsor. So the divorce does not end the sponsorship. I want to make that very clear. Just because you divorce the person you filed for does not end your responsibilities, your obligation as their sponsor. I will tell you what does, but I just want to make that clear that divorce does not end that. All right. There's 4 things that end it, and divorce is not one of them. So let's go into when the obligation ends. All right. If the person that is a permanent resident loses their permanent residency, either by giving it up or by immigration court finding them deportable and taking away their green card. When that happens and they are no longer a permanent resident, your responsibilities end. Okay? Another way for that permanent resident to no longer be a permanent resident is if they become a US citizen. So it's either they lose the permanent residency or they become a US citizen, and by becoming a US citizen, they're no longer a permanent resident. So if they become a US citizen, that obligation goes away because now you no longer have to support them. All right. The next one is if the person dies. So if the person that you supported or sponsored dies, then the obligation also dies. And then finally, if the person that you have sponsored has 40 qualifying quarters of work in the US. This is the part that gets people. 40 qualifying quarters basically means 10 years, right? They have worked in the US for 10 years. And when I say work in the US for 10 years, I mean under their own Social Security number, and that the Social Security Administration can actually print out documentation saying, yes, this person has 40 qualifying quarters. All right. So it's not just, if you're in the US and you've been here for 20 years and you've worked for 20 years, but you've only had your green card, you've only had authorization to work for only 5 years, you have not met the 40 qualifying quarters because you need that full 10 years qualifying quarters, okay? And it needs to be while you're in status. That's the part people forget. Because if you're not in status, you're most likely not getting W-2s, and it's not being put with the Social Security Administration, so they can't actually track any of that. And the Social Security Administration is the only organization that can certify that you have met the 40 qualifying quarters. All right. So that's about 10 years of legal employment in the US. So if the person you sponsored for a green card has 40 qualifying quarters in the US, meaning about 10 years of legal work in the US, if they die, if they lose their permanent residency, either by giving it up or by being in deportation proceedings, you also lose your obligation to them. And then finally, if they become a US citizen, you also no longer have an obligation to them. So it's really important that as you're going through the affidavit of support process, you're thinking about whether you want to sponsor or be a joint sponsor. So usually if you're filing for your spouse, if you're filing for your parents, you do not mind being a sponsor or a supporter because that's your family. However, if you are a joint sponsor, a co-sponsor, and this is for a friend, for a distant relative, you may, want to know what that responsibility is and when it ends. And one thing I tell people is technically, when it comes to this, you don't have to wait for the 40 qualifying quarters. If the person can apply for citizenship, have them apply for citizenship to end that obligation. If you are getting a divorce, just know that it is going to, it can be enforceable in some states. Okay, the affidavits of support in divorce proceedings can be enforceable, meaning that you cannot So if you're going through a divorce and the person you sponsored, right, your spouse that you sponsored, can use the affidavit of support to then say that you can, you have to continue supporting them, especially, and this is really only if they're not working or if they haven't been working, and the court still has to look at whether it's even appropriate based on how long you've been married and your financial responsibilities. But I have seen that being brought into divorce cases. So know that as well. As a joint sponsor, that's not really something you need to worry about because you're not married to the person that you're sponsoring. So that divorce will not be affecting your responsibilities either. All right. So if you have questions, like I said, put them in the comments. I will be answering those. I just wanted to get through that because, again, you want to know what your responsibilities are as a sponsor, as a supporter, especially when you're filing an I-134a or an I-864, because, again, you do have obligations and you want to know how long those obligations last and what you have to actually do for the person. And for the most part, the I-134a is the one that actually has things for you to do for the person, making sure they have a safe place to live, getting employment, applying for work permit, helping them get access to resources. Whereas the affidavit of support for the I-864 is basically saying if this person ever needs financial support, I'm willing to help them. They're not going to need government assistance. So that's really the key difference there. And then for the I-134a, it only lasts as long as the person is in parole. If the person leaves the US and loses their parole, your responsibilities are over. If the parole term ends, your responsibilities are over as well. And then for the affidavit of support, if the person dies, if the person loses their permanent residency, if the person becomes a US citizen, and if they have 40 qualifying quarters of work in the US, which is the equivalent of 10 working years in the US, then your responsibilities as a sponsor ends as well. All right. So I do see comments. I see questions. So I will be getting to those. Okay. So if you have questions and you're joining me live, ask me. If you're joining, if you're watching this on the replay and you have questions, go ahead and ask me as well. Okay. All right. So John has a question. Can results of TB to be positive, then X-ray became negative, can result of rejection of adjustment of status? So it depends on if it's cleared, then the doctor will clear the person. So the medical exam is what controls. So when the person does their medical exam, if they pass the medical exam, which typically if the person is positive for TB, they will do the x-rays and all that and wait for it to clear. If it does clear, then they will update the medical exam before it is sent to USCIS or the embassy. But if you do the medical exam and it's positive for TB and you don't take the steps to clear the TB, guess what? The doctor is only going to base it on what they have there, right? And if you don't meet the requirements, which being negative for TB is one of the requirements, it can be your adjustment of status can be denied. So there's a difference between rejection and denial. Rejection is if, let's say, your I-485 filing is not complete. So there's a page missing. There's something that's not checked off to help them know where to place it. That's a rejection. But a denial is you don't meet the requirements. And having a negative TB test is a requirement. So that will result in a denial if the medical exam report shows that the person is positive and did not take the steps to clear it. All right. Perfect. My wife is on process for her adjustment of status through I'm guessing that's an I-485. Can she travel to Kenya and come back to the US by using her L2 visa? So I typically do not recommend that. Okay. You need to apply for advanced parole. That's what you need to do. If she does not apply for advanced parole and travel on advanced parole, the U.S. government, USCIS, can deny the application based on, excuse me, based on abandonment. So once you file that green card application, you should not be traveling unless you have permission to travel, and that's with an advanced parole document. All right, I'm just gonna get some water. Let's see. So on Instagram, bleak as I am waiting for my pending VAWA case. It's been 2 years and 5 months now. My old work authorization has expired, and I'm trying to do the medical exam to submit along with the I-485 and I-764 based on VAWA, but I don't have a valid ID at the moment. Can I still do the medical exam without a valid ID? That is a question for the medical the doctor doing the medical exam. Okay. If you do not have a valid ID, they may have other means of confirming your identity, but you need to contact the medical the physician that will do the medical exam to actually do that. All right. It is not, yeah, so each medical physician does it differently, so you need to contact the ones in your area to see what their requirements are as far as ID is concerned. Some may allow you to do an expired ID with a birth certificate or something of that nature, but it's really up to them on what they are allowed to do. USCIS does have rules for them. They have rules for them to follow. So they would need to basically certify how they confirmed your identity in order for that to be accepted. Okay. All right, next question. My daughter filed for me March 2023. I live in the USA. I got my EAD 2 months ago. My I-130 got approved last week. Just got an RFE for my I-485 asking for my I-94. Am I close to getting a decision? Well, maybe, right? If they had the I-94, they would have made a decision. By not having an I-94, sending it in, sometimes the officers are, they still have it on their desk and they are able to just go ahead and make a decision. And sometimes they already put it in a separate pile that they will need to get back to later. So yes, you were close to getting a decision, and the sooner you can send that in, the better for your case. The less time between the request and you actually sending the document, the better. But it's not like months later and the officer already put it on a separate pile. Okay. So the sooner you can get it to the officer, the better, as far as if you're close to getting a decision. If your I-130 was approved, that means you were close to a decision. Okay. The officer just didn't have what they needed to go ahead and approve your case. They need the I-94. They need proof of how you came into the US and when you came into the US. And that's what the I-94 does for them. It tells them when you came into the US and how, that you came in with a visa, or that you came in with parole. However, they want documentation of that. And if that's not in your documentation, they can't actually approve your case. Okay. But yes, you were close. All right. Next question. Hi, I am a US citizen filing for my wife. Can I use my children who are also US citizens living with me for the affidavit of support? Yes. So your children living with you would be household members. Okay, so they're not filing a separate affidavit of support. You can just include their income. They will file an I-864a. So you're filing an I-864, they will file an I-864a to basically say they're a household member and give their financial information. But yes, as long as they're living with you in the same household, they will count as a household member, right? So when you're filling out your affidavit of support, you need to count your children as part of your household, and then you can use their income to make up the difference. All right. So also counting them as part of your household means that your income requirement is going to be higher now than it was when it was just you and your wife. All right. So that's just something to keep in mind. Counting them as a household member increases the income requirement. If they can do, you can also have them do a separate affidavit of support, because then they wouldn't be counted as a household member. It's a whole analysis that we do, but if it's easy to add them as a household member and their income is enough combined with yours, do that. It is completely allowed, and you can definitely use children living with you that are part of your household. All right. So if you have any questions, please continue to put them in the comments. If I don't see any questions, then I am going to end the live. So ask me questions. Last call. If you are joining me live, watching this on a replay, and you would like some help with your immigration needs, go ahead and schedule a strategy session with me. This is a free 15-minute session where we talk about your immigration situation, your needs, and how I may be able to help you with them. You can do that by going to my website, lilylegal.com, and click on Contact Us, and you will be able to pick a date and time that works best for you, and we can talk about your immigration needs. You can also schedule that strategy session by calling my office at 508-443-1788. All right, so I do not see any new questions. So again, feel free to ask questions. If you're watching this on a replay and you have questions, go ahead and ask them. I do go back and respond to those. And next week, Friday, is going to be our monthly Q&A session. So if you have questions and you are not able to ask it today, just know you can always ask it on the video. Once it's posted on YouTube, you can put your question in the comments, or you can also go ahead and send me an email with your question. Just say YouTube live question, or you can come on the day of the live, which is next week, Friday, and ask me your questions live. Think about what you want to ask me and bring it with you, okay? Like I said, goal is to answer your questions, and again, can only give you general answers, okay? Can only give you general answers here, but if you want a more in-depth conversation about your particular situation, scheduling the strategy session is the best way to do it. The link for the website is on the bottom of the screen, and also someone asked on Instagram, so I put it in the comments there as well. Good question, Michael. So he's asking the petitioners pay for the I-864, the I-864a, the I-864w do not have a fee attached to it. Okay, the I-864 is just an affidavit of support. There's no fee to file an affidavit of support. But if you are using household members, they will be filing an I-864a, not an I-864w. Okay, the W is for people that don't need an affidavit of support. So by filing an I-864W, you're saying this person does not need an affidavit of support for these reasons. But in your situation, it may be best to just do an I-864A or have the child do a full I-864. All right, next question. Can a US visa be denied based on the fact that a parent is living in the US illegally? Can they reapply? So yes, this is one of the downsides, right? So yes, it can be denied for that reason. If the parent applied for a visa and overstayed their visa, if the parent is in the US without documentation, yes. Okay, so um, that's just how that works. All right. If they're in the US without documentation or they overstayed their visa, the US Embassy, if they know that information, can use that to deny the child visiting visa. That's what I'm guessing you're referring to, not really an immigrant visa. So if you're applying for permanent residency, that wouldn't be considered. But if you're applying for a non-immigrant visa, then that would be considered, because you're basically saying you're coming here temporary and then you're going to go back home. But if they already have evidence that a parent or a sibling is in the US and they overstayed their own visa, they're going to use that against you to be like, oh, but are we going to trust that you're going to come back as well? Okay. Can they reapply? Yes. But you need more, right? Part of the visiting visa or the non-immigrant visa is showing your ties to your home country. So if you do not have ties, or if you do not have more than what you had on your initial application, you may want to wait till you have more. But yes, your parents being in the US illegally can affect you. Yes, you can reapply, but you want to make sure that you have more to show for ties to your home country before you do that reapplication. You don't want to just apply with the same exact information again. It's not going to be helpful. All right. So if your case has been approved, doesn't mean a decision has been made yet on your case. If your case is approved, then there's a decision on your case. Okay. It does not. All right. So if a decision has been made, if your case is approved. So the decisions on cases is it approved, denied? Those are the only options. It's either approved or it's denied. So depending on your type of case, it may see once it's approved, you'll get a notice saying it's approved. The only case type that you do not get a notice saying that it's been approved is the citizenship. So if you're applying for naturalization, you will not get a notice saying that your case has been approved. You will get a notice for an oath ceremony, okay? Because they just don't send out a notice saying your N-400 has been approved, but they will send a notice saying you've been scheduled for an oath ceremony. You're only scheduled for an oath ceremony if a decision has been made on your case. Okay. So just want to make that clear. And if USCIS wants to make a different decision on your case, if you look at the case status, it will say your case has been reopened. Okay. If it doesn't say it's been reopened, then the decision still stands. So for example, we've had a green card application where a decision was made. We got the notice saying that the decision is approved, and then they reopened it because they approved it under the wrong category and then had to reopen it to issue the right category, and then they still approved it under the wrong category, so they had to reopen it a third time to review that. So if it says reopened, then that means they're trying to decide if they're going to keep the decision they have made. If it says cases actively being reviewed, that's different. So sometimes that just means that let's say, for example, if they're trying to issue a card or if they're processing something. So if you ask a question about your case and the officer goes in there and looks at something in your case, it's going to change to cases being actively reviewed. Okay. So so when you look at the case status, it will go from approved or scheduled for oath ceremony, and then you see cases being actively reviewed. It just means that an officer went into your file at some point and looked at it. It does not mean that they're actually reopening the case or making a different decision. The decision is still there. It's just an officer was in your file. And this happens a lot if you call USCIS or if you do like a request to USCIS. That's where you will see that happen. But yeah, I hope that answered your question. If you have any other questions, put them in the comments. If not, it has been a pleasure. And remember, if you want a strategy session, the contact information is at the bottom of the screen. lilylegal.com/contact us, and you'll be able to get a strategy session with me by scheduling a date and time that works best for you. You can also call my office at 508-443-1788. Thank you so much for joining me. Remember, next week is the Q&A, so bring your questions, ask me in advance. Happy to answer. Okay. Mr. Tusk, I'm going to save your question for next week, okay? But I do see your question. I am going to save it for next week. I do have videos on next steps, but I will be saving your question for next week. All right. So come back next week and I will be more than happy to respond to it. So if you're asking questions right now, I'm going to be saving all of it for next week's Q&A. So don't feel like you have to stop asking me questions. Just know I'm going to have to save it for next week. Okay. All right. Thank you all so much for joining me. And I hope you have a great rest of your day and a great weekend. Bye.